Okay, welcome again, everybody. Today is Thursday, April 25th, 2024. Welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Linker, will you please take roll?
Baker,
Here.
Commissioner Ortiz, Commissioner Wilson,
Here.
Commissioner Wood,
Here. Sorry.
Chair Silver.
Here. Thank you, Ms. Linker. My apologies for the mask. Hope everybody can hear me. Feeling a little bit under the weather, but we're going to power through. For those of you who weren't with us last week for our law and policy meeting, my name is Adam Silver. I'm the newly appointed chair to the Fair Political Practices Commission. It's an absolute honor to serve in this position at the agency where I started my career. I have a deep respect for the FPPC and its work and its mission. And in my personal opinion, the commission, its staff, my fellow commissioners, they're truly assets to the state of California. So I want to thank the governor again for this tremendous and humbling opportunity to serve at the helm of this important agency at a time that's critical for public trust and democracy. I also want to take this opportunity to thank my predecessor again, Rich Madish, for the excellent work he did, as well as staff and my fellow commissioners for the tremendous work that they've done in terms of promoting transparency, educating public officials, and diligently enforcing the Political Reform Act, among other achievements. Thank you for your dedication. I look forward to working with all of you. Prior to my appointment as chair, I worked as chief counsel of the Assembly Legislative Ethics Committee. In that role, I advised Assembly members and staff on the ethics rules, including the provisions of the Political Reform Act. I believe that experience, combined with my time as commission counsel in the FPPC's enforcement and legal divisions, will give me an excellent foundation to hit the ground running as chair. But I also recognize that, that could give the appearance of a potential conflict of interest under certain circumstances, which is something I take very seriously. So with that in mind, I plan to take a broad approach to recusal in regards to my previous employer, one that goes far beyond what is required by law. And I think this is important because I believe that the regular Californian, they're not familiar with the statutes and regulations that govern conflicts of interest in the state of California. I don't want to give them any doubt as to whether I'm acting within the law, the FPPC is acting within the law, and we're acting within their best interests. So specifically what I plan to do is I'm going to recuse myself from any matter that specifically names the Assembly, an Assembly member, or Assembly staff. So with that, enough about me. Why don't we move on to item 1, and that's going to be public comment for items that are not on today's agenda. Do we have any public comment? Seeing one, could you come up, sir?
Yes, sir. I'm here to complain about the fact that 2 complaints generated by the citizens of Dixon, California have been seen no resolution. I filed FEPC number 2022-00756 regarding an AdWatch violation, and an anonymous individual who I know filed number 2022-00620 regarding a councilman who is alleged to have a 1090 code violation. As there's an election coming up in relatively short time, it is imperative that these complaints are adjudicated as quickly as possible. The city is contemplating another shot at a sales tax increase, and it's looking to raise water rates. The city should not be allowed to campaign as they did during the 2022 election season, using public funds to do so. Your own website has the following. Regulation 18420.1, which states that the timing, style, tenor, and timing of the communication has to be considered in campaign material. The city of Dixon filed or sent out 3 campaign brochures in October, right around the election time, talking about all the key points as...
I apologize for interrupting you just for one moment.
Certainly.
So we are a quasi-judicial body. Just want to make sure that we're not prejudiced as to any enforcement item that might come up on a future agenda. So if you could just not go too in the detail on any of the items that are before the Enforcement Division. I'm going to let you finish, but I just want to let you know that timely resolution of enforcement cases is going to be a priority and has been a priority for the FPPC. And I'd recommend that you follow up with our Chief Enforcement, Lindsay, on these cases. And I'm sure that he can give you an update as to what's going on. But go ahead and finish.
And that's fine. I appreciate that, but it's been a year and a half. Nothing has happened. That's what the point of me being up here today is. I will try to leave out the the other things. Anyway,
Thank
all
you.
of the criteria have been met. So why hasn't your legal staff addressed this as yet? I received an email CC from the city attorney that's defending the city, and it had Caitlin Angeloni's email address on it. I advised Miss Angeloni that I wished to meet with her and the legal team looking into this. I received a curt response that if she had any additional questions, she would, quote, let me know. I consider this a brush off. I advised her that I would attempt to meet with her at these offices and come to this meeting. When I came here a week ago, I was told by a Mr. Cameron of the SEI unit that most of your attorneys work from home. This is a far cry from how the FBPC operated at its old offices over by the train station. I was told I could send an email complaint. I was told I could do a PRA request. I'm attempting to help you uphold the law. Enabling your staff to hide from the public who pays your salaries with our taxes is antithetical to your purpose. The Dixon City Attorney is Doug White, who has often told me he worked for or with this organization. Is that an additional reason for not finalizing this case? This specifically applies to the second case, which I'll be filing a formal complaint in the near future. Then I go on to talk about that case, so I'm going to respect what you had said and not talk about it. But as 1090 carries the penalty of never being able to hold public office again, this is no minor complaint. It's related to a lease of a public building that he voted on, and that's all I'm going to say about that. These people are coming up for re-election, and because of that, that's why I'm here asking for action instead of stalling this out. And it's been a year and a half, like I said, and I don't know who your chief of staff is, but I passed out my cards or gave them to the secretary so that you can all have my card. It has my contact information. I started an online newspaper, and that's what the card is about. Thank you. And that's all I have. Thank you.
Good morning. Am I next?
Mr. Chair, I hope I'm not interrupting, but it's possible we've lost audio on the Zoom. We can't hear the committee room unless Commissioner Wood is able to hear and it's just me.
No, I heard somebody on the phone though, but I
Yes, I
didn't
think-
hear the commission room. Yeah.
There we go. Okay, it looks like they're switching out the chair's mic.
Okay, we have a new microphone, but we still can't hear the public commenter.
Mr. Rowan, if you are on the phone, please go ahead.
Good morning. My name is James Rowan, and I would like to echo the commission chair by saying that the Fair Political Practices Commission is the most excellent commission for fair political practices in the country. I would also like to say that the staff have worked with me, and I find them excellent and good. I'm originally from Santa Clara, and Santa Clara was once known as the Silicon Valley's Mayberry. It is now, due to the San Francisco 49ers, turned into a version of Checkpoint Charlie. There are two active complaints regarding Jed York dealing with setting up a phony nonprofit called Santa Clara Now. The commission is dealing with it. I am not trying to prejudice the commission or the commission staff, which are excellent, but I beg you to consider the ramifications. Like a billionaire in Washington to try to overturn the government, Jed York, a billionaire in California, is trying to overturn the government of Santa Clara. Santa Clara is not a place for millions of dollars to be spent into a local election. Indeed, St. Clair, the statue, according to Jed York, should have a red and gold helmet on it. The past lobbyist for the San Francisco 49ers, Raul Chanduk, and it's in the San Francisco Chronicle, wanted to hire private investigators to follow civil grand jury members into their church. These sorts of things, commission members, strike at the heart of fair political practices. The commission from 1974 has done a tremendous job. And one of the first rulings the commission made was at the advice of the mayor, Gary Gilmore, who set the standard for conflict of interest for local governments. It's still called the Gilmore Rule. So I would really beg the commission to forward as much as possible the complaints dealing with Jed York in his attempt to overturn the mayoralship of Gary's daughter, Lisa Gilmore, and to try to continue the ethical standards that Santa Clara won awards in. Thank you, and may God serve all of you. Good day.
Thank you, sir, and thanks again to our previous public commenter for going ahead and monitoring this sort of activity and proactively going ahead and filing complaints. You're really the first line of defense in making sure that these rules are upheld. So go ahead. Do we have additional public comment? Go ahead.
Good morning, Mr. Silva. Congratulations on your new position. I'm sure you'll do a good job. Steve Petzold calling from Santa Clarita, California. Back in March, I made a suggestion that FTPC had general counsel look into whether citizen bond oversight committees appointed in line with the requirements of Prop 39 bonds be required to file Form 700. I don't know what the progress is on that, and that's why I'm calling today, because I would like to see it expedited. It seems like it would be relatively easy for somebody to look at Government Code 8100, then look at the Education Code, and for what the duties of Citizens Bond Oversight Committees do, and determine that they are not purely ministerial or ceremonial. They have direct obligations to report to the public and to the trustees of local entities about the expenditures of bonds in accordance with Article 13 of the California Constitution. So I don't know what so long to do that, but certainly at College of the Canyons here, the Chancellor and the Board of Trustees exempt members of the Citizens Bond Oversight Committee from their conflict of interest codes. So, it's self-serving because the whole purposes of bond oversight is to oversee the activities of decisions made by the trustees and the chancellors. So in looking at your agenda today, the first one is for the fire battalion chief who got entangled because his wife, he wasn't required to file a Form 700. So I suspect he unwittingly stumbled into that. And I don't know how anybody ever came up with a complaint because they didn't have the Form 700 to look at to see any possible conflicts by him or his wife. So I would like to see this expedited. There are going to be billions of dollars of school agency bonds on the ballot in November. And I don't know whether there has to be a notice of proposed rulemaking or how any decision will be promulgated to the school districts, the bond councils. Once you actually, if you make a determination that they're subject to Form 700 filings, the attorneys and the bond councils are going to be bouncing off the walls. Citizens bond oversight.
And sir, sorry to interrupt you. 30 seconds left. And I believe our general counsel, Dave Bainbridge, has an update for you. I believe we'll be examining this at our upcoming Law and Policy Committee meeting. Is that correct, Mr. Bainbridge?
Yeah, that's correct. This came in originally as an issue in Law and Policy in March. Law and Policy instructed us to look into it. So I'll be coming back with a report in May with some general information about both the conflict of interest code adoption process as well as some specific information about bond oversight committees and where they fall within that process.
Excellent. Well, thank you for that update.
Well,
and
that's
I hope
pretty
that you
fast.
join us for that,
Thank
that
you.
committee hearing. Go ahead, sir. Any additional public comment? Okay. Hearing none and seeing none, why don't we move on to item number 2, and that's going to be approval of last month's commission minutes. Do any of the commissioners have any edits or suggestions for last month's minutes?
Motion to approve.
I can second. Okay.
Excellent. Any public comment on that item? Hearing and seeing none. Ms. Linker, will you please hold that for a vote?
Commissioner Baker,
Aye.
Commissioner Ortiz, Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Excellent. Now we have the consent calendar. We have 3 items on the consent calendar. Are there any items that a commissioner would like to take off
Yes.
for separate consideration?
Number 3.
Number 3, excellent. Thank you. Okay, so we got number 3. Any other items? Okay, so we're going to take number 3 off of the consent calendar. We're going to leave items number 4 and number 5 on the consent calendar. So I believe we're going to go ahead and make a motion for approval of the consent calendar first before we talk about item 3. So can I get a motion for that?
Okay.
Or
Motion to approve 1 and 3, 1 and 4 or something.
well, why don't we do a motion to approve the consent calendar
Yeah.
items?
Motion to approve the consent calendar.
Second.
Excellent. Can you please take the roll?
Commissioner Baker,
I don't know if there's, maybe there doesn't need to be public comment, and I'm not going to interfere with that, but aye.
Commissioner,
Go ahead. That's a good point, Commissioner Baker. Any public comment on the consent calendar items? Seeing none, hearing none. I'm getting a shaking of a head from Sasha, so it looks like we don't have any. You can go ahead. You didn't change your mind, did you, Commissioner Baker?
I did not.
Okay.
Solidly, yes.
Commissioner Ortiz,
Yes.
Commissioner Wilson, Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Okay. Welcome, Chief Lindsay. Looks like we're going to now consider item number 3 in the matter of Anthony Anderson. Are there any opening comments you'd like to make on this before the commissioners pose their questions? Thank you. I have one quick question just to start off our conversation. So I noticed this arose from a state auditor's audit. Could you give us some additional background, or I should say, what additional background could you give to us on that piece that's unique? I haven't seen that in the past.
Yeah, so this is emanating from a whistleblower complaint to the California State Auditor. The auditor's report is a public document. Much of the detail in there isn't necessarily incorporated into the stipulation, but there is some additional detail surrounding that matter. Is there anything specific that you were hoping maybe to glean from that?
Whatever you think is relevant. It's helpful to know that this arose from a whistleblower.
Yeah.
Anything else you'd like to share?
I think the thing that struck me that maybe was the most interesting is that although we do note it as mitigation, that Mr. Anderson, that the construction company, Ron Paris Construction, did projects for the unit at CAL FIRE prior to Mr. Anderson becoming employed. It is important to note that Mr. Anderson was employed at surrounding units and was familiar with the assistant chiefs in question in this matter prior to that time, and was actually the individual that gave the referral of this construction company prior to his joining that area. So I think that was the thing that was probably the most interesting in addition to what we've got in the stipulation.
Excellent. Thank you, Commissioner Ortiz.
Thank you. Thank you. I'm conscious that conflict of interest is a violation, as you say in the thing, of could provide the greatest harm, public harm. And I understand that there needs to be a violation there needs to be a fine for a violation once it has been found. The thing that made me is that Mr. Anderson was not required to file 700s, didn't know the act. He told his superiors that he was working for that, and nobody told him at that, at that point, hey, we need to talk about this, or bring in the general counsel of that CAL FIRE to talk to him. So that's what it made me kind of, and I'm going to vote yes because it's a violation, but it made me, the word is not uncomfortable, but I don't know what the word is. It's because of all these things that happened that he showed good faith in many ways.
Yes, I understand that, and I think that's actually reflected in the penalty and the number of counts that we have. Well, okay. There was technically eight different times in which Mr. Anderson signed invoices. We could have charged as many as 8 counts here. We chose to knock those counts down to 2 because of the fairly significant mitigation. It is important to note that although unusual to some degree, an 87-100 violation is not dependent upon someone being a filer. Public official is defined more broadly than that. And sometimes individuals aren't placed in the local conflict of interest code for whatever reason. We have had scenarios in the past that we have charged individuals for 87-100 violations, even though they were not SCI filers. And of course, it's also important in this case that it's also a 1090 violation. So here we chose to go with 2 counts based upon the invoices signed in 2019 and 2020 because it's a conflict of interest case and it's a 1090 case. And I think, even Mr. Anderson recognized clearly that this was a conflict. He wouldn't have talked about it as much as he did if he didn't recognize that, I think. We do charge typically something very close, if not the max, per count on a conflict of interest scenario.
Is 5,000 the max? What is the minimum?
The minimum is typically 1,000.
1,000. And so to charge the max in here, as according to your memo, is because of the amount that was involved?
Yeah, that's one of the things. In fact, oftentimes in 1090 situations, we would look at a number that might be close to what the contractual value is. In this case, because there is significant mitigation that you have articulated, we chose to do something a little different to take into account that mitigation and the fact that he wasn't a sole actor.
Good. Thank you.
You're welcome.
Lindsay, thank you for covering those initial issues.
Sure.
My key question is, it's clear that Form 700 was not required here, but did the division chiefs have an obligation to file Form 700? Do we know the answer to that question?
Yes, my understanding is yes, they did have to file.
So it seems that all the parties were aware of the family relationship with the business. And so my question is there any option, or did you consider whether the division chiefs could be fined under the act?
I came into this much later than the opening of the case. There would have been a possibility to charge the individuals potentially without knowing all the facts related to those individuals. There is the ability to charge for aiding and abetting under 1090 for sure, and probably also really because they were filers and had filing obligations, they could have been charged potentially for 87-100 violations as well. But in this instance, based upon the auditor's report and how the case came in, we decided to move forward against Mr. Anderson solely.
And I accept the conclusion that your staff determined that this was either negligent or inadvertent, but there are still some issues that I think are come into play as to why this wasn't dealt with at a higher level, to realize that because there was a connection with the family's business, that a different vendor or contractor should have been used. What is the maximum fine that could have been imposed in theory?
In theory, I would say that there could have been eight violations over the 8 specific invoices that were signed, each being their own contractual obligation, and therefore it would have been $40,000 potentially as a maximum fine.
And then my last question, just for the benefit of the public, who actually, what is the source of payment for Mr. Anderson to pay the actual fine? Does it come out of his own personal funds, or is it?
Yes.
Okay. All right. Thank you.
You're welcome.
Great points, Commissioner Wilson. And one thing I want to piggyback on that, I think it'd be helpful if we have our division that deals with conflict of interest codes reach out to the agency that respondent is at, and just discuss whether or not someone who is engaging in this sort of decision making should be or should not be a Form 700 filer. It seems to me in general that a public official who makes or participates in governmental decisions, which it appears this individual does, should be a Form 700 filer. So hopefully our staff can reach out to them and assist them with making any changes that are necessary.
I think that's an excellent idea.
One additional. Okay, Commissioner Baker.
I defer to the chair, and I'm happy to wait in line. Thank you.
No, go ahead. I've talked enough.
My colleagues have asked good questions. I appreciate that, as well as the chair's recommendation that there be a conversation with the agency about their conflict of interest code and potentially upgrading it. Question I had, have just two. One is, are we able to, I think this has come up before, either require in stipulations that the individual take training, or when that outreach to the agency regarding conflict of interest happens, can we even vote today that they conduct a training for everybody there, so that we're kind of going the extra mile? We have great educational resources on this, and in many ways this is exactly the scenario that we just shouldn't have happen. Can you comment on that, and either the ability to require that of others or of this recipient and his supervisors who gave him bad feedback?
Sure. Mr. Anderson is retired now. In terms of the CAL FIRE, they're probably the agency that needs potentially a discussion on this. They're not part of the stipulation, so it wouldn't have been available to us in this particular scenario to require them to do something in a document that they aren't a party to. However, the suggestion that Chair Silver gave for us to perhaps refer this to our code reviewing body here internally and have a discussion, I think that's probably where we are and the best thing we can do here.
Well, I thank you. I appreciate that. And I don't know if there's any further we as commissioners can go when that outreach happens to both offer and strongly encourage a training. I'll let you find out the right way to be persuasive in that and deferential. So I don't know if there's additional input on that, but I have a separate question.
I think Mr. Bainbridge wanted to make a comment to your recent question.
Thank you.
Yeah, on the question of the conflict of interest code, this is a state agency, so we are the code reviewing body for them. So we do work with them in adopting their code. It's up to them to identify what different positions do, and then we review the code and determine if we think those positions should be included in the code or not. So there has been some contact with them just in the normal course of every couple of years. We review codes or amendments to codes, but we can have someone reach out to them regarding this issue and see if they have questions about who should be designated in their code and who shouldn't be. I'd also note that depending on the level of the employee, there is state mandated ethics training, which we're all familiar with, and I don't know enough about this particular situation if he would have had that, but that is routinely given every couple of years to state officers.
A quick follow-up: there is evidence to indicate that he did have training.
Interesting. Not in the stipulation. Well, that would be a good thing to see in there for future notation. Obviously, I know these things are negotiated. I may have a question for Mr. Bainbridge on this, actually, and follow up is there anything from this stipulation and the facts that have come forward to us that we look at and say, hey, since we are the agency that approves or basically approves their conflict of interest code, is there anything more we can do to make sure agencies are identifying all the people? For example, do we ask them, did you consider the people who signed the contracts, which is the case in this respondent's situation? That may be more for Mr. Bainbridge.
Yeah, I'll be honest, I haven't read this stipulation thoroughly. It's out of my department. But generally speaking, I'd have to examine exactly how we do the code review process. But I think I can report back on that when I come back on the Oversight Bond Committee and And it's sort of all related to how codes are created and how agencies, the law requires that the codes be created at the lowest level with the understanding that those are the agencies that understand how the agency operates. So I will add that to the list of things to come back to law and policy and potentially the commission about when we have a bigger discussion about how conflict of interest codes work, if that pleases the commissioners.
And I'll let of course, it be deferential to my colleagues on this as well. But for my part, I think it would be valuable to see now once this is, and I believe I'm going to support it, but it's final, so we're not involved in it. If we can look and see if there's anything that can be done differently, including the question, now this might be at a micro level, who signed your contracts? And if there's any other way. So I'll look forward to that update. And thank you. That seems a very smart and efficient way to do it. My follow-up is, and this is more feedback, because Commissioner Ortiz raised a great question about, we want people to go to their supervisors and say, hey, I have a connection here. What should I do? In talking about training and the conflict of interest code, that's one way to address it. But in this instance, I would have potentially treated it as a different mitigating matter, because now we have a comparable that has two maximum amounts charged, $5,000 for each, even though not all of the counts that were possible are there. So when this becomes a comparable in the future, it's less. I may offer that I would have preferred to see a lower amount and maybe more charges, and the lower amount reflects this isn't the worst actor who eyes wide open did something, and despite feedback that they shouldn't do it, they did it anyway. This is someone who should have some more mitigating factors. I'm just mindful of the comparables here. And I just want to open that up. If you have any comments on that, easy for me to say I would have done it differently, but that's the feedback I'm allowed to provide, is that I would have mitigated it differently, knowing how we use comparables in the future. And piggybacking on that, are there any comparables that you had where the individual, the comparable that you identified doesn't really have a lot of details, but it doesn't seem to be a situation where the person went to their supervisors or contacted somebody else in charge and disclosed the issue, and they were told to do something different? I'm sorry, they were told that it was okay. Are you aware, and did you look for any comparables for that and how we treated it? So those are my two comparable points. Thank you.
Yeah, there's different. Thank you for that. There's different viewpoints on how to work with the comparables. They're available for others as well, and I think conflict of interest is such a serious violation that we tend to look at not having low numbers, because then that becomes an argument with everybody else that thinks they have some mitigating factor that maybe we don't share in terms of the level of mitigation that should occur. So we tend to look at reducing counts versus reducing numbers, and we're perfectly aware of our comparables, and we look at those matters. So I think that we use them properly internally, but that's the reason why we make that choice.
Understood. I just will say again, if there were comparables that were, and I do believe the staff knows them quite well, certainly better than I would, and perhaps other commissioners, but finding one where there's a situation where the person made some best efforts would be something I would look for in the future, as well as I mentioned about if, as you said, he actually took the training, because I think that is a relevant point. I intend to support this, easy to quarterback it or Monday morning quarterback it, but those are my thoughts given where we are. Thank you.
I appreciate that. Thank you.
Mr. Wood, any comments?
No, I really appreciate that entire conversation though, because it was a really it was like a little heart-wrenching to read it, because it felt like, he had tried to be transparent in some ways. And so I felt bad for him, but I also will support it.
I agree, and I support the stipulation as well, while acknowledging and agreeing with a lot of the points that were made today. I echo what Commissioner Baker said. I think we should note in the future, especially in a circumstance where it's unclear whether there's a requirement that they take the agency training, whether they did or did not. And then I think it would be helpful in the future. I don't know if it was noted in the STIP. I didn't see it that this individual retired. Was that included in the STIP?
I think so.
Okay. Well, if it was, I think that's excellent. I think that should be included because I think that goes to, continuing public harm. I think that'd be great to include in there. On that point, I think staff did an excellent job pointing out the public harm that arises from conflicts of interest. I think it's one of the more egregious violations of the act, and one of the main reasons why I support the stipulation today. So with that, I move to Commissioner Wood. Go ahead.
Sorry, I just very quickly on the thing Commissioner Baker was saying about comparables, it really got me thinking. One way to avoid the problem that she raises might be to mention when we're talking about the I'm calling them comparables, but you know what I mean. Anyway, when we're talking about them, to mention how many possible counts there could have been brought. So we have a sense of what percentage of the counts were brought, so that within each count, if it goes all the way to the limit, that's one piece of information. And that's the piece that Commissioner Baker says could be complicated in the future with this one. But if we know it's only 2 out of a potential 8, right, then that helps us understand that only 25% of the charges were brought. And so it actually was a little more of a lenient penalty than it could have been. So in the future, when we talk about these cases, when we're trying to think about what the appropriate penalty should be, both of those pieces of information might help us kind of gauge what the prior enforcement decision really was. Does that make sense?
Yes, it does.
Okay, cool.
And I think it's important to recognize this is a very unique set of circumstances. I can't imagine that we have very many previous fines for conflicts of interest for individuals who were not Form 700 filers who went to their supervisors to disclose that they may have a conflict, right? And I also think it's going to be helpful here that we have all of this on the record. So, I appreciate Commissioner Baker, Commissioner Wood, Commissioner Wilson, Commissioner Ortiz, all commenting on this. So if in the future this sort of item comes before the commission, we can look back and see whether this is consistent with the enforcement STIP at that point, or it's distinguishable. So with that, do we have any other comment from commissioners? Okay, well, I'm going to move to approve this item. So can I move and then ask for public comment? Okay, excellent. So I'm going to move to approve item 3. Do you have a second? No one wants a second?
I can second.
Okay, excellent. Here we go. That was a close one. So before we vote, though, we're going to do public comment. Do we have any public comment on this item? Excellent. Seeing and hearing none, will you hold the vote, Ms. Linker? Commissioner Baker?
Aye.
Yes.
Aye.
I didn't hear my name, but I think I'm up next. Aye.
Aye. Excellent. Well, now let's move on to our general items. We're going to start with item number 6, and this is going to be a pre-notice discussion of the proposed repeal and adoption of Regulation 18932.3, honorarium ban exception, definition of predominant activity. And today we have Senior Commission Counsel Karen Harrison presenting. Thanks for joining us, Ms. Harrison. Good morning.
Good morning. Is
You have
that
to
better?
get very close to
There
that
we
microphone.
go.
I got to remember that too.
That's a little, okay. All right. Good morning. I'm Karen Harrison, Senior Commission Counsel with the Legal Division. I am here to present the proposed repeal and adoption of Regulation 18932.3. This defines predominant activity for purposes of the earned income exception to the honorarium ban. This proposal is presented for pre-notice discussion this morning and will be presented for adoption at a later date. Before I start talking about the regulation, first I want to do a brief overview of honorarium ban and the earned income exception. Since the 1990s, the Act has prohibited candidates for elective office, elected officers, and office holders specified in Section 87200 from accepting any honorarium. An honorarium is defined under the statute as any payment made in consideration for any speech given, article published, or attendance at a public or private event. There is a limited statutory exception for payments that are earned income, and this is defined as payments that are for a personal service customarily provided in connection with the practice of a bona fide business, trade, or profession. The earned income exception applies unless the sole or predominant activity of the business, trade, or profession is making speeches. This is Section 89501B. The earned income exception allows a bona fide business, trade, or profession that customarily involves making speeches to receive payments for these activities, speech, articles, appearances, but only so long as speech making is a component of the business and not the sole or predominant activity. Section 89501 specifically authorizes the Commission to adopt regulations to implement the earned income exception. So, current regulation 18932.3 defines speech making as presumed to be the predominant activity of an individual's business, trade, or profession if more than 50% of the hours or gross income is related to making speeches, and this includes the preparation and delivery of speeches. There's 2 time periods that are used for making this determination. If the business, trade, or profession has been in existence for more than a year, you look at a 12-month time period. Less than a year, it's 30 days. The time periods allow for a rolling examination of the business, trade, or profession's predominant activity relative to the speech in question. To avoid abuses, the gross income and hours related to the speech in question are included in making the determination. At the June meeting, the Commission discussed the application of the honorarium ban related to an informal advice request. At issue was a local elected official who, prior to becoming a candidate, had an established book writing and promotion, or book talk, business. The official wished to know, generally, if she could continue to be paid for book talks, i.e. making speeches under the honorarium ban. It was noted that her business had cyclical activity, income and hours, tied to her books. This resulted in 1 year a book might be published, and then payments would be received and hours accrued. Then in following years, it would be promoted. And as a result, while the core of her business may be her books, her predominant activity in those later years related to the promotional activity, making speeches. The result is that the determination that predominant activity of her business in the 12-month period that was being examined would be making speeches. And under Regulation 18932.3, the earned income exception was not available. It did not apply. The Commission discussed this issue specifically in regard to long-standing businesses and directed staff within the limitations of the honorarium ban statutes to propose narrowly tailored regulatory changes to address the application of the honorarium ban to situations such as this, involving a long-standing business, trade, or profession with less traditional hours and income cycles. Staff has worked on this, and proposed Regulation 18932.3 adds an additional time period, 36 months, including the date of the speech, where the business, trade, or profession involves a proprietary work created by the individual and where the business, trade, or profession has been in existence for at least 12 months before the individual became subject to the honorarium ban. Staff also proposes non-substantive reorganization of the regulation. This requires the repeal of the existing regulation and the adoption of the proposed version. And just as a quick summary of the proposal, proposed subdivision A states the existing requirements, the existing standard, that more than 50% is the predominant threshold, and the hours and gross income related to making speeches are the activities of the business, trade, or profession relevant to the determination. Proposed subdivision B1 and B2 state the current time periods and the existing requirement that predominant activity is determined prior to and including the speech-making opportunity. Where the business, trade, or profession involves proprietary work created by the individual, proposed subdivision B3 provides a 36-month time period. as the period for examination. This also includes the activity prior to and including the date of the speech. To minimize the potential for abuse, the 36-month period is applicable only in instances where the business, trade, or profession has been in existence for at least 12 months prior to the time that the individual became subject to the honorarium ban requirements. The 36-month period is based on research into traditional publishing arrangements, and then proposed subdivision C defines terms used in the regulation, such as proprietary work, which is defined as a tangible or intangible item made or sold by one having the exclusive right to manufacture and sell. And then clarifies that this includes items such as a published book or licensed computer software. These are two examples of proprietary work that involve an initial advance of payment for an item up front, and then income or hours later for making speeches to promote the item. Staff proposes the repeal and adoption of Regulation 18932.3 as a solution to situations involving long-standing businesses with non-traditional activity cycles. Are there any questions?
Thank you for that presentation. That was excellent. And I
Okay.
really appreciate the regulation. I know you've done a lot of research on this. This is a tricky topic that requires you to go back and look at the intent of the voters, which I know was discussed at length back in June of 2023 at the meeting. I know this is on pre-notice, so I'm going to have some questions, some potential examples to pose. And if you don't have an answer for that, that's absolutely fine. That's something we can address further down the line rather than speculating. So my first question relates to, let's see the specific language, proprietary, and you can, there we go, proprietary work. So I was thinking about that specific provision of the regulation, and I was concerned that that wouldn't cover, or at least not so much concerned, but I was interested to know whether we think that would cover a article that's published in a medical journal in the context of a written work, or perhaps you have a CTO who works at a tech company, right, and they work on a specific piece of software, and they themselves, they don't have the exclusive right to manufacture and sell it. Their company does, but they're clearly an expert in that area, and they might be paid to speak about it. So if you could speak to either one of those circumstances, I guess I could express myself more succinctly, where there is some sort of work where the official does not have an exclusive right to manufacture or sell it.
So those are good questions, and I think what we would look at, first of all, when we say exclusive, it means that that individual has the right to sell that product, whether that right is theirs 100% or shared with somebody else is something that we are not excluding when we say exclusive right, but as to their interest, they have a right to that. And the important thing here is that it not be something where maybe they're drafting a book, but they haven't published it yet. So we want something concrete that has been created, that they have rights to sell, that they have rights to market and be paid income. But in that CTO example, first you'd need to look and see, is there a bona fide business that this person has? They have to show a record that the business exists. And then you would look to see if it's something customarily provided as a part of that business. So one question I would have is this already part of their employment contract? Would the promotion be part of that contract and their salary? In which case it might fall in a certain category. So those are facts that we would like to look at, and so I will definitely report back. But there's a number of factors to look at in this process.
Excellent. Were there any other comments or questions that commissioners had? Commissioner Baker, go ahead.
Thank you, Mr. Chair, and thank you, Council Harrison, for this. It was a very clear memo, and I remember the robust discussion we had in June. One of the takeaways I had from that discussion was we wanted this to be narrow. And I think you've done about as good a job as we can come up with for how to make this narrow. But we also wanted your team to come back to us and say, look, we just don't think this is in the spirit or the letter of the law. Now, I'm taking the fact that you're coming back with a proposal and a change is that you and the team are comfortable that this is not, this is within the spirit and letter of the law, and it's not really stretching. I'm asking for a personal characterization here. Do you feel this is a stretch or well within the honorarium ban? I can only imagine you would say yes, it's well within, but if you think it's a stretch, I'd like to know.
No, that's a very good question because loopholes are a huge concern when you're drafting honorarium regulations. And I take my hat off to the folks that drafted these regulations back in the 1992 time period. It took them over a year to do so. This was carefully drafted. It wasn't our first attempt. We had several attempts we had to throw out. We are comfortable that this is within the authority that we were given and that it is an expansion of the time periods looked at, but it is well within the statute to include this time period.
Thank you. I remember coming away from that conversation, it may have been Chair Matich or a fellow commissioner saying, look, if you needed to come back to us and say, we just don't think this is it. So we didn't want to give you a direction that go make this exception and figure out how to make it work. It was, and if you have to come back and say, can't do it, can't do it. And that's what I'm taking away from this conversation is you feel comfortable. My only other second point goes to the proprietary definition and understanding. And I'm trying to imagine, especially at this pre-notice stage, potential areas of abuse. Can you tell me how, for example, someone who's perhaps a columnist and they write, columns, and it could be in a maybe well-established paper or publication, or it might be in one that is a blog, would be able to then maybe they get elected and they come back and they're doing more op-eds and that legislative interest groups would really favor or potentially oppose, and then they're getting paid an honorarium for it, big amounts. Do you see this scenario that I've given you as a potential loophole? And if so, that would be my direction at pre-notice, is to see how to, if it's necessary to work around that.
It's a good question. I think the rolling determination assists us there in that you're going to always reference the speech that's coming up and whether or not predominant activity of the business falls over that tipping point of more than 50% of the gross income or the hours spent during that time period. If they fall over the 50%, then their predominant activity would be making speeches and they would not be able to do it under the honorarium ban. But again, you're going to do the same analysis for that columnist. You're going to look and see, do they have a bona fide business? And so they need to meet that standard, show that there's a bona fide business and show that this is something customarily provided within that business. And then you're going to look at those time periods in order to determine predominant activity. 36 months does enable you to have a broader time period, but it does balance out those instances that we were requested to address where somebody might not have something in the traditional 12-month period. So to answer your question, I think that it will expand it somewhat, but I am not seeing the opportunities for abuse because of that rolling time period.
Mm-hmm. Well, I'm going to keep that. Thank you. And I'm going to keep that fact pattern in mind as we see these return to us. I'll be very interested in hopefully some robust public comment and discussion about it during the pre-notice period, because I am trying to imagine those, excuse me, many people who are interested in running for office are in an advocacy space, whether it's writing here or there. And if that is the primary source of their income leading up to that rolling period, and then if they get in office, if that it opens the door for them to be paid. So I'm going to be keeping that in mind, and I thank you for the response and the work you've done on this.
Thank you. And I appreciate all those comments and feedback because we are posing hypotheticals and we are trying to envision how this will play out. And so all of the testing is helpful.
General Counsel has a comment?
Yeah, just to add to Commissioner Baker's first question and Ms. Harrison's answer, when we had this discussion back in June, we were focused more on whether we could change the definition of predominant activity so that it was less activity, less than 50%, or whether we should change the definition of speech given. We hadn't really considered this idea, and I wouldn't give him credit if he was still here, but since he's not, I will. Former Chair Matich actually came up with the original idea of extending the time period in which we look at for predominant activity. Because we were pretty adamant before that this needed to be legislation because we hadn't thought of it from this perspective. But I think when looking at it in terms of not necessarily changing the definition of predominant activity, but just expanding the time period for longstanding businesses, I think it fits well within the statutory intent.
Thank you so much, Council Bainbridge. That's very helpful to hear. And, I guess we ought to thank Chair Matich again, but since he's not here, that's the appropriate thing to do. Excuse me.
Wilson?
As a follow-up to Commissioner Baker's questions, and I know this will be down the road because this is pre-notice, but have you thought about, or maybe you will think about, a situation where you have an elected official who's acting in good faith under these regulations, assuming they're implemented, but then they accept a, honorarium payment? What would be the course of action if there were an issue of whether they were entitled to that actual honorarium? So let's say they get paid $1,000 to give a speech. They think it's within the scope of this regulation, but it actually isn't. Would they be subject to some potential fine, or have you thought about that at all?
So I think I understand your question, and I think one of the things to understand about the predominant activity determination is that it needs to be determined what the predominant activity of the business, trade, or profession is prior to the speech being given. But you're including the anticipated income and the anticipated hours of activity. So that examination under the current regulation needs to be done ahead of time, and this regulation merely extends the time period. And then I think that we are talking about an enforcement action if you violate the statute. I'm just gonna
Looking at
clarify
me as
with
she
you.
says that. It would be a question of how enforcement wanted to handle it. So if the rule changes, the conduct happened before the rule change, and then after the rule change, technically the law would be as it was before the new regulation went into effect, but it'd probably be something enforcement would consider in determining how they want to handle the enforcement case.
Council in me wants to jump out and say they would have 30 days from the receipt of that honorarium to go ahead and return, reimburse, or take another action within the statute to reverse that potential violation as well.
Thank you.
Please correct me if I'm wrong on that one. So another thing to consider as to Commissioner Baker's comments, we do have this current definition of predominant activity, right? I think it's important to consider whether we've seen an abuse of that current definition. I think it'd be helpful. I think we'll consider this again at Law and Policy, but if there's anything that can speak to that, whether we see people who currently are operating under the bona fide employment of journalism as a journalist, who may be engaging in the sort of activity that Ms. Baker pointed out, right? I think that'd be helpful. I think it'd also be helpful, as I'm taking a closer look at this, is to better know how we arrived at these three different time periods. So we have 30 days, 12 months, and 36 months. So what was the reasoning behind setting out those time thresholds?
So looking back at the original file when these regulations were passed in 1992, the idea was that 30 days would give you an accurate picture of what a business's predominant activity was if it was a new business, and it would limit opportunities for abuse. And the same on the 12 months applied to businesses that have been in existence for longer than a year. And I don't think the analysis was more complicated than that of when can you get a snapshot so you can determine predominant activity. That was the requirement under the statute, and that's how the commission determined they would have that period of examination.
Excellent. With that, that's helpful. Commissioners have any additional comments? Okay, well, why don't we move on to public comment? Is there any public comment on this item? Hearing and seeing none, let's move on to item number 8. That's going to be adoption, or I should say, we're going to move on to item number 7, actually, because we're going to go in order. That makes a lot of sense, right? So number 7, pre-notice discussion of new regulation 18450.10, an amendment of regulation 18450.9, website advertisements, disclosure requirements. Welcome, Commission Counsel Caitlin Baida Oric. Appreciate you being here today.
Good morning, Chair and Commissioners. Caitlin Bieda Oric, Legal Division Counsel, presenting 2 regulatory updates for pre-notice discussion in response to Senate Bill 678, which added Section 84513 to the Act. This new section requires individuals who are paid by a committee to post content on a website, web application, or digital application in support of or opposition to a candidate for elective office or a ballot measure to include a disclosure on the posted advertisement stating that the committee paid them for the post. These regulatory updates presented today include new Regulation 18450.10 and amendment of Regulation 18450.9. First, staff recommends adopting new Regulation 18450.10 to clarify the new disclosure requirements for advertisements posted by individuals on the Internet. Based on the legislative intent of SB 678, it has been determined that the new disclosure requirement under Section 84513 is intended to apply to third-party influencers who are paid by a committee to post content on the Internet. This is distinct from content posted by the committee on its own page or account, or those created by traditional vendors that a committee pays for advertisements, as these ads would be covered by the electronic media ad disclosure requirements under Section 84504.3. Accordingly, the regulation draft provided today states that a person is considered an influencer if they post content in a manner that appears to deliver their own opinion rather than that of the candidate or committee. In addition, staff recommends repealing subdivision B of Regulation 18450.9 as a result of SB 678 adding Section 84513. Because now there is a specific disclosure requirements for these types of advertisements, and therefore this language is no longer necessary. I have an example here for further explanation. Not sure if I can get that on the screen. This first post reflects the application of existing Regulation 18450.9b disclosure requirements prior to the passage of SB 678. This regulation required the author to provide a tag or otherwise include a link to the committee's social media profile or landing page of the advertisement. With the passage of SB 678, there are now specific disclosure requirements for these types of advertisements, which require disclosure similar to the second example I have hopefully on the screen. Oh yeah, here it is. As you can see, the disclosure is now required on the posted advertisement as opposed to simply tagging the profile.
Sorry to interrupt, but we can't see it on Zoom. The second one, we saw the first one.
Sorry, and I believe the one you displayed initially was supposed to be the second photo. But
No.
It is the same post, just the
It's the second one.
Just the the disclosure just changes. There you go. So that is
thank
how.
you.
So after the passage of SB 678, this is now the requirement for these types of advertisements posted on a website. And do note that the disclosure is only placed at the beginning of this post, just for visibility reasons. The way that it created, it only allowed a minimum of 120 characters to be visible, but that is not the requirement of the statute. The statute only requires that it be legibly written or clearly audible if it's in an audio format. And so I'm happy to take any comments or questions regarding these regulatory updates.
Any questions from the commissioners?
Yes, that's correct.
That's unlike this one. That's the original one.
Yeah, the first one just has a tag to the candidate or committee's profile or account or landing page. And the second one has the physical disclaimer on there saying paid for by or paid by in connection with this
And that's
posting.
what.
Yes, that is the new
proposal
requirement.
That they will require that.
Yes.
Okay, thank you.
Any additional questions from commissioners? Great. Any public comment on this item?
Sorry.
Go ahead, Commissioner Wood.
Sorry. I just wanted to I appreciate the work that you're doing here. This is a set of regulations that I followed really closely over the years because of my own work. And I have a student right now writing about these influencers and how the FEC isn't regulating this yet in the same way that we are. And so I was able to pass this to her and show her, and she has found anecdotes of kind of political operatives saying that they really want to move toward using these influencers a lot more in their messaging. So it's just really well timed here. So I know we did it because there was a statute amended, but I just wanted to thank you for your careful work on it because I think it's very timely.
So here it says if this proposal will be considered in June for the commission. If the commission approves it, does it take effect immediately?
I believe that's within 30 days.
On 25.
So this is already in statute. This is already the requirement by
Okay.
law. We're removing the requirement we have in our regulation.
Okay.
And then we're clarifying with the change to the regulation, this is the rule. But the actual rule is already in place through the statute.
Great. Thank you.
Thank you.
Excellent. Well, we don't have any public comment. Well, I guess I'll ask again just in case. Any public comment on this item? Perfect. Okay.
Can I, sorry, just one
Sure.
additional thing. I'm sorry I send these things out scattershot.
Yeah, this is
It's
a whole
hard when I
bit
do
that
this
me and Commissioner
remotely.
Wood worked out before the meeting. Go ahead, Commissioner Wood.
No, I just, it feels to me that it would be most helpful if the on-ad disclosure comes at the beginning of whatever the influencer is going to be saying, as in the example that you gave. Do we have statutory authority to require where in the comment block that that on-ad disclosure would come?
All eyes are on me again. My initial reaction is no, I don't think we do. Based on the way the statute's worded, we will check into that though before we bring it back. I would agree it's better to know it up front, but I don't know that we have that authority. But we'll confirm that.
Gotcha. Okay, thank you. I'm really done now, Mr. Chair. I'm sorry.
Sounds good. Okay, and I encourage the regulated community, if you have any concerns, questions, suggestions related to this, to provide us with feedback, either when this is heard for adoption, or at our law and policy meeting where we're going to bring this up. So with that, one last time, public comment, seeing and hearing none, we're going to move on to number 8. Item 8, adoption of proposed amendment regulation 18537.1, refunding of general election contributions. And I believe our general counsel has an update on this item.
Yeah, to refresh everyone's memory, we brought this proposal in March, right now, February. Brought this in February, I can't remember now, February or March. And the instruction from the commission at that time was to put it off a month and see if legislation was going to be put forward, as had been indicated, to address this issue. There already was legislation that existed addressing the other issue that we had attempted to get resolution on through this regulation package. At that time, they have since, I believe it was yesterday or the day before, amended their legislation. It's SB 948 to also address this issue that we were specifically going to talk about today regarding what to do with general election campaign funds if someone wins outright in the primary election. So the proposed legislation now addresses this issue. They have chosen to draft it in a way that would choose what we have called option 2, which is allowing committees to transfer the general fund money that they have raised for the general election that they didn't end up running in with attribution, as opposed to returning it, which had been our suggested path. And so given the instruction last time, I think it would be wise for us to just hold these regulations until September or October, whenever the legislative cycle has passed, and then see if there's anything left for us to do by regulation at that point. That seemed to be the commission's instruction last time. We're prepared today to give a presentation, but if that is the commission's will, we'll save everyone's time and maybe talk about it during the legislative session of the meeting today, and we can bring back the regulations again if the legislature doesn't resolve the issue to our liking after the legislative session. So that would be my suggestion. I don't think we need to take action on it as long as there's a consensus of the commission that we don't hear this item today and potentially bring it back in a few months.
Excellent. Well, I support that, so it sounds like we wouldn't have to take a motion. With that said, any comments from commissioners before we move forward? Commissioner Ortiz?
We comment on these things, or we don't comment, or what is the thing? What is since you're asking us to postpone it, what do you want us to do? Can we comment? Can we ask questions?
Yeah, well, so we can do it a couple different ways. If the will of the commission is to wait on the regulation, we can discuss the policy question in the legislative portion of the meeting today or in future legislative portions, because the legislation basically chooses one of the options we suggested for resolving this particular issue. Or we can discuss it now as part of a discussion of the regulation.
Which I have to say I was inclined to do 2 instead of 3. So what, Mr. Chair, what is...
Commissioner Wilson?
What do we do? Do we offer comments or questions or what?
Well, I'm in support of what General Counsel Bainbridge laid out in terms of not taking any action on this item and bringing it back should the legislation that addresses this issue not go, not go through, and then we still have this ongoing issue going. So that's how I feel.
To shelve it for September, postpone to September this conversation.
Correct.
Okay.
Correct. Yeah, but Commissioner Wilson?
I would agree with Council Bainbridge's recommendation. Since SB 948 is moving through the legislative process, it probably makes sense for this quasi-legislative body to wait until this issue is resolved one way or the other by legislative action.
And our attorney, Zach Norton, who has been working on this for almost a year now, is available, and he can be available for the legislative portion discussion if you'd like his expertise or to answer questions. He's here today, and we can do that during the legislative session if we'd like, or in future meetings.
Excellent. I can tell you I've watched Zach's presentation multiple times. It's an excellent presentation. You did an excellent job breaking down all the different issues, different options. So I just wanted to recognize you and legal division staff for doing such an excellent job with this complicated issue. Commissioner Baker?
Thank you. Just because we're looking for consensus, and I agree with this approach of postponing adoption of anything until after the legislation's had a chance to take its course. But also, I think this goes to Commissioner Ortiz's question. In today's legislative update, have a more robust discussion with Chief Counsel, Legislative Counsel, Senior Legislative Counsel Nakano on the options and what the bill says, and if Zach could be available for that, that would be very nice. Thank you.
Mr. Wood? Any public comment on this item? Okay, seeing and hearing none. We're going to move on to item 9, which is going to be our legislative update with Senior FPPC Legislative Counsel Lindsay Nakano. Good morning, Ms. Nakano. How's it going?
Chair Silver, I do want to highlight that there is a public commenter for item 1 that joined us a little late. Whenever you want to take that.
Okay, well, I know this can be a pretty long item, so does anybody take issue with us circling back to item 1, and that is public comment on items not on the agenda? We can hear them out and then circle back to this. Does that work?
Fine.
Excellent. Go ahead. You can proceed. Public comment.
Hello, can you hear me?
Yes, I can hear you. Thank you.
Thank you so much. Hello, FPPC. I'm here to report a major concern to myself and the public. Attorney General Rob Bonta and his office have been engaging in a conflict of interest for a university, something that AG Rob Bonta's office is supposed to have oversight over. He and his office are receiving gifts from, as well as members of his office are receiving compensation from. This conflict of interest has resulted in the Attorney General's office refusing to acknowledge evidence of a crime that this university has committed according to a government agency, having served charges of discrimination to the university after an investigation took place that saw the university tamper with evidence to exonerate themselves and then retaliate against me by suspending me as a student for engaging in protected activities that also, I believe, include me reporting this matter to the appropriate bodies. When evidence from United States Code that clearly states the Attorney General's obligation to investigate and handle these matters, such as Article 5, Section 13 of the California Constitution, as well as Cal Government Code 12650, 12651, and 12652, on top of Executive Ordinance Number 12250 on November 2nd, 1980, 45 FR 72995, set out as a note under Section 2000D-1 of Title 42 of the United States Code, which further obligates the Attorney General to enforce the laws regarding access to education are presented to the Attorney General's office, and they are indifferent towards it, it becomes a matter of public harm. The rule of law requires enforcement for the law to have meaning. The charges of discrimination from the DFEH states that, quote, additionally, the respondent contacted my previous school in an attempt to gain slanderous information about me. The respondent then used the untrue and unsubstantiated information to discredit my allegations, end quote, which is a violation of California Penal Code 141 PC that states that no one may tamper with, suppress, or conceal evidence to exonerate or implicate anyone. The Attorney General's Public Inquiry Unit has refused to investigate and continues to ignore the evidence, and also the office continues to accept compensation through public funds to give legal representation to this university named CSU East Bay, as well as the CSU Board of Trustees. The AG's office has also refused on several occasions to identify any rule that prevents them from carrying out their duties to the public outlined in Article
Just
5,
interrupt,
Section 13.
sir. You just have 30 more seconds. Go ahead.
Oh, okay, yes. I believe this matter to, I bring this matter to the FPPC to investigate and then provide the results of that investigation to the public and any evidence that is found to be a conflict of interest, that this body use all of its power to hold the appropriate agencies accountable to the full extent of their power. I also further fear further retaliation from these bodies for reporting this matter. If they're willing to engage in these type of activities, who knows what else they're willing to do to keep the truth hidden and escape accountability. I ask that you see what evidence I have, as well as see what other conflicts of interest are occurring from this office and its leader, Rob Bonta. This is clearly a matter that concerns public trust, public harm, and deserves to be dealt with seriously, if not urgency. Thank you so much for your time. My name is Matthew Morris.
And thank you for reaching out to us. And I'd encourage you, if you've not already filed a complaint, to reach out to our Chief of Enforcement and go ahead. Actually, my Executive Director has clarified that we'd encourage you to file your complaint via our electronic filing complaint protocol on our website. You can go take a look at that. One additional comment, just for you to note, just keep in mind our jurisdiction is limited to the Political Reform Act as well as Government Code Section 1090. So just keep that in mind as you're going ahead and filing a complaint if you should decide to. But thank you again for that public comment. And Sasha, do we have the commenter's name and contact?
Name, I can get a contact from him.
Excellent. Thank you so much. Okay, well, let's go back to item 9, legislative update.
I apologize for the interruption, Mr. Chair. I don't think we can hear Miss Lindsay, but perhaps Commissioner Wood, are you able to hear? I don't think on Zoom we can hear.
We can't. Thank you.
And then Ms. Nakano, if you could just get closer to the mic. I'll make sure to do that myself as well.
All right, how about now?
Perfect.
Okay. Good morning again, Mr. Chair, Commissioners. There are 22 FPPC-related bills active now. As a general update, all of the 22 bills in the legislation report have passed through the first House policy committees, except for 4 bills. 3 are set to be heard next Tuesday, and 1 is actually in hearing now. I've been monitoring that hearing for about the last 20 minutes. They should be voting on that in the next few minutes, but I probably won't have that update today. The bills are now making their way through the appropriations committees. Many of the bills have costs that reach the suspense file thresholds, which mean that they will be held in committee until the suspense hearing on May 16th, which happens to be the same day as the May Commission meeting. So depending on the timing, the update on which bills make it out will either happen in May or June. On to the individual bill updates. There are a lot of bills to keep track of, so I'll do a quick blurb about each one before any updates. I'll start with commission-initiated bills, but please stop me and let me know if you need clarification on anything. AB 1170 by Assemblymember Valencia would require individuals for whom the commission is the filing officer to file their SEIs or Form 700s directly with the commission using the commission's electronic filing system. We're continuing conversations with the author's office and stakeholders, including the City Clerks Association of California, regarding how to ensure smooth implementation if the bill passes. AB 2001 by Assemblymember Gallagher, making minor changes to the PRA, and SB 1027 by Senator Menjivar relating to redaction of bank account information on public copies of statements of organization, both passed in their respective first houses on the consent calendar. AB 2631 by Assemblymember Mike Fong, which would make the FPPC's online local ethics training program a permanent program and statute, was placed on the suspense file in the Assembly Appropriations Committee. Costs include one position in the IT unit and education software. SB 1404 by Senator Glazer would transfer the mandatory lobbying audit workload from the Franchise Tax Board to the FPPC and would impose an additional fee on lobbyists to offset the costs of that audit workload to the state. The bill was amended to cap the amount of the new fee at $500 per lobbyist and adds that only those lobbyists who are subject to audit would be charged the additional fee. That bill was heard in the Senate Elections Committee and passed 5-0 with Senators Nguyen and Newman not voting. The bill is now on suspense in the Senate Appropriations Committee, and the FPPC's costs include 6 to 7 new positions in the Audit Division. I'll pause here for any questions or discussion on commission-initiated bills.
Mr. Wilson?
Thank you, Councilman Nakano. I think it would be helpful for the public if you could explain what the suspense file is. I think there are people that work in the legislative arena that still don't understand that, but I know that you do. So thank you.
Absolutely. So I have the thresholds here. So basically, if a bill reaches a certain monetary threshold that it will cost the state, it is held in the Appropriations Committee with all of the other bills that reach those thresholds, and the Appropriations Committee votes all at once in one day which bills will pass out according to the fiscal situation of the state. So in the Senate, the threshold is if the bill has $50,000 or more in general fund costs or $150,000 or more in special fund costs, it will be on the suspense file. And in the Assembly, the threshold is $150,000 regardless of the funding source.
Commissioner Baker?
Thank you for this update. On the last bill, SB 1404, I appreciate that you mentioned that the fee would be applied only to those lobbyists who are subject to it. Does that mean only the lobbyists who's randomly drawn and therefore audited, or a class of lobbyists are excluded? Can you clarify that, please?
Yes, thank you for the question. So it would apply to anyone who is subject to the drawing, not only those who are polled. So it would exclude placement agents and lobbyist employers who employ only placement agents, as well as lobbying firms and lobbyist employers that have less than $1 in payments. So basically no activity in the reporting period.
Great, thank you. That sounds good.
Helpful. Could we get some more background on that bill specifically? You know, I wasn't tracking it too closely in my previous position, but I was pretty surprised to hear about the statistics in terms of lobbying audits. I can tell you, myself, Senate Ethics Counsel, Aaron Peth, we do the state lobbyist ethics training that all state lobbyists have to attend. And, you know, one of the reasons that we encourage, that we cite for lobbyists to consider and really paying close attention to these reports and making sure they're timely and accurate is that there could be audits. And if a violation is found, you could be prosecuted. right? But it sounds like there have not been audits. There's been very low amount of audits, right? So you can speak to that much better than I can, obviously. So that would be helpful to go through.
Certainly. So this issue has been on the commission as a broader entity on the commission's radar for a number of years. Every 2 years under the Political Reform Act, about 300 lobbying audits are required to be conducted. Currently, though, that workload is with the Franchise Tax Board. It came to our attention a number of years ago that almost none of them were being completed for the last several audit periods. In some years, 0 were completed. So this was obviously very disturbing to the commission. Audits are important for a number of reasons, especially for enforcement purposes. It's one of the main ways that violations are found for lobbying reporting violations. So this having no audits being done means that we are simply not very likely not finding violations that are occurring.
How long has this deficiency been going on? It sounds like for much longer than 2 years since prior to COVID.
I think the records that we have looked at have gone back, I think 4 or 5. Our executive director has information.
Hello. Can you hear me?
I can.
Hey, it's working. So basically, there was a public hearing held by Senator Glazer that produced a report that we will also post on our website. And he went back to the 2013-2014 session, and his numbers found that although 121 and 183 lobbying firms and lobbying employers were drawn, only less than 3% were completed that year. And that's the first year that he reported. And then each year after that is lower, down to 0 certain years. So all those numbers are public, and they do show that this has been a workload that hasn't been done for at least 10 years.
Okay, so if it's been going on for that long, it's clear, I assume, to the regulated community, that essentially these audits aren't even happening, right? So we lose that deterrence that I mentioned during that ethics training. What has the FTB explained as the basis for them not being able to complete these audits?
At the hearing, it was, I believe it was their CFO was explaining that they don't have the resources to complete these audits. And the conclusion that I was hearing was that the campaign audits are where the resources are going, but they are only completing 30 to 40% of those. So they don't have the resources to then go on to the lobbying audits.
So I'm sure, the regulated community, basically everybody, the public especially, they agree that this is an issue that we need to resolve. Are there alternatives to this? It sounds like the FTB has sought to resolve this issue and has not been able to. It's existed for 10 years now. Have there been other efforts to address this, or does this seem like what has to be done to ensure that audits of lobbyists are conducted?
Well, I believe Senator Glazer looked into other options and found that since we have an independent audit division and the specialty of our regulations in this area as well, that we would be the most logical place to then have this workload. We're also not a revenue generating agency, so we don't have the temptation to move assets away from certain programs because they don't make money. For those of you that don't know, we don't keep our enforcement fines. They don't go into our budget, so we don't have any incentive there. So for us, it was a logical step to agree that we could handle this workload, and it would also inform us to be able to make new regulations that work better or find things that are issues and address them through legislative or regulatory process.
I think those are really important points that you make. And that was one of the reasons that we actually created an independent audit division, correct? To eliminate even the appearance that, our audit division is coordinating with enforcement on these sorts of audits.
That is correct.
Okay, that's very helpful. And for pointing out that we don't actually keep the fines. I
We
can't
don't
tell
keep
you
the
how many
money.
times we hear that at the lobbyist training. Excellent. Well, I'm glad that we could, shine a light on this this issue one more time. I'm going to open it up, see if any other commissioners have any questions on this specific piece of legislation. Commissioner Baker, go ahead.
my colleagues will indulge me, I just think this is one of the most important bills of the 22 plus that is on here. When I first joined the commission, back in December of 2020, January 2021, and I remember when I first heard about this, and some of our predecessor colleagues on the commission heard about this lack of audits being done, we were just floored and really see such a sensible solution. Obviously, we have to have the funding and the support to go with it, but we have the expertise, we have the structure, and I really hope we can put as much support and energy into this bill as we can, and it would be good. And think about how many times we've had enforcement matters come to us only because of an audit. So that's my soapbox. I don't think any of us disagree, but I just want to be on record again as saying this would be one of the highest priority bills, I think, before us. Thank you.
Any other comment? Okay, I'm almost ready to get off my soapbox. Last thing on this item. I can tell you that lobbying reports, complying with the lobbying rules, can be very complicated, right? And a lot of times new legislation, new rules will come into place, and we won't consider how that'll impact filling out some of these forms, complying with the rules, et cetera, making payments to SOS, who's receiving those payments, right? So I think it'd be really helpful if we could work with the author's office just to make sure that we're really considering how this is going to impact the practical aspects of complying with all the lobbying reporting requirements. Because we want to make sure that, hopefully if this goes into place, that there's no complications with paying this fee, with paying the other fee related to doing the trainings, who's going to receive these payments, all those really practical items. I think it'd be great to have those ironed out before we go further down. That's all the comment I have on this piece of legislation.
For either Executive Director West or anyone, Mr. Nakano might want to respond. If this measure were to pass, are you confident that there would be enough funding available to ensure that the FPPC could absorb this responsibility?
Yes. So basically, we've looked and relooked at the numbers and the fees that are proposed by Senator Glazer. It is a little unusual for us because we've never had a special appropriation in any way. So we're making sure that we're working with Department of Finance almost weekly on this bill to make sure that we understand how we would get the money. And there's a delayed implementation date that would allow us to staff up with the funding. And we're looking into options of asking for temporary funding that would facilitate us fully staffing this to have it up and running.
Excellent. I don't know if we take public comment on specific bills, but we'd certainly welcome it. So if there's anybody who has any public comment on this bill before we move forward to the rest of our update. Hearing and seeing none, go ahead, Ms. Nakano.
Thank you. Okay, moving on to other commission-related bills. AB 2041 by Assemblymember Bonta, which expands the permitted use of campaign funds to certain security expenses, passed in the Assembly Appropriations Committee 13-0, so that bill is continuing to move along. AB 2573 by Assemblymember Mike Fong clarifies that the services of a fellow provided by the Asian Pacific Islander Capital Association to a state agency or the legislative branch are not gifts under the PRA. That bill passed in the Assembly Public Employment and Retirement Committee 7-0. Staff are exploring the possibility of broadening the clarification in the bill to the services of all similarly situated fellows, since that is consistent with FPPC advice. The author's office has indicated interest in that idea, and we're working on language to ensure that the provision would be appropriately inclusive. AB 2654 by Assemblymember Vince Fong. This is actually a new bill. It was amended on April 18th to newly amend the PRA, and this one was actually in hearing during this commission meeting, and not sure what the disposition of that hearing was, but the bill relates to non-disclosure agreements relating to the creation of legislation. The bill would prohibit lobbyists and public officials from entering or arranging non-disclosure agreements relating to the creation, drafting,
or negotiations relating to legislation. The Assembly Elections Committee analysis for this bill highlighted a news article from last month that stated that private parties that were negotiating language relating to the fast food minimum wage law signed NDAs to protect the confidentiality of negotiations. And the author's office stated that the need for this bill is transparency relating to legislative work.
Quick question on this item. So is it going to add language to the PRA? Is that why we're following it?
Yes, it's in the Political Reform Act.
Okay, excellent. Thank you for clarifying.
And this bill, I wasn't able to see the end of the hearing, so I'm not sure what happened to it, but I'll give you an update next month. All right, AB 2803 by Assemblymember Valencia would prohibit campaign funds from being used for certain criminal legal defense costs. That bill passed in the Assembly Elections Committee 8-0. The bill was amended. Previously, it would have prohibited the use of campaign funds for legal costs relating to crimes of moral turpitude, dishonesty, or fraud, and those terms were not defined in the bill. The bill would now instead prohibit the use of campaign funds for legal costs associated with a felony described in Section 20 of the Elections Code or any felony involving fraud. The crimes cited in that Elections Code section include a felony involving accepting, giving, or offering to give any bribe, the embezzlement of public money, extortion or theft of public money, perjury, or conspiracy to commit any of those crimes. So those would be the types of charges for which campaign funds could not be used for. The Commission had questions about this bill, and the amendments do address some of them. The author's office clarified that they intend the bill to apply to only criminal convictions, so some refinements in the language are still needed.
Would the candidate who uses those funds for these purposes, these prohibited purposes, would they be required to reimburse their campaign committee?
Yes, if they are convicted, they would be required to make that reimbursement.
Okay, excellent. Thank you.
Okay, Commissioner Baker?
If it's all right with, excuse me, if it's all right with the chair, actually, it raises a question. If the account was closed at some point, by the time maybe appeals happen and everything else, just to clarify for the public, we have a process where if reimbursement is due back to a committee that's been closed, there's a way somebody can do that. I don't know if they have to reopen it or how that works, but I just want to make sure that's whatever happens here is consistent with that process. And I'm sure that's already been
I'll
thought of.
defer to our general counsel on that one.
Yes, that's correct. We have a process within regulation that allows for reopening of committees to deal with refunds and these sort of things. So whether they have to reopen the committee or they can dispose of it in other ways, there is a regulation that would dictate that.
Okay, and presumably this would apply. Just want to make sure as we look at this bill going forward. Thank you.
Any further questions on this one? All right, moving on. AB 2990 by Assemblymember Lowe would put a strict time limit on FPPC administrative and civil actions by prohibiting enforcement actions from being brought more than 2 years after the Commission receives a sworn complaint, audit report, or referral, or 2 years after the Commission commences an investigation on its own accord. The bill was amended to provide that the new time limits would apply only for violations occurring on or after January 1st, 2025, the effective date of the bill. The bill passed in the Assembly Elections Committee 6-0 with Assemblymember Lackey and Assemblymember Alanis, who was temporarily assigned in place of Assemblymember Saley, not voting. Staff do have concerns about this bill. First, some respondents relating to the time limit. Some respondents could take advantage of the limit and intentionally stall the process. Second, there are many circumstances where cases simply take longer. For example, if there's difficulty obtaining necessary records or a case is particularly complicated. The time limit would affect the ability of the Commission to vigorously enforce the Act and could potentially prevent the Commission from being able to properly investigate major violations. The bill is headed to the Assembly Appropriations Committee, and FPPC staff are in the process of analyzing the fiscal effect of the bill, which we anticipate will be significant.
Any comment on that bill? Okay. Commissioner Baker?
Particularly vocal today. I appreciate my colleagues On this one, in the regulations that we adopted ourselves, or the policies that we adopted ourselves for the whole dealing with backlog and cases going forward that our enforcement team's been reporting on, we have I want to say almost an off-ramp or an exception or a process for dealing with cases that are going past 2 years. And that is come to the commission and explain what's going on. And does this bill have it? And my feedback is, if it doesn't, and it makes it out of the appropriations committee, we may need to engage very robustly on having, whether you want to call it an off-ramp, a stopgap, how do you deal with cases that haven't, because of the reasons you're mentioning and that we all know. The respondents can drag their feet. Evidence can be voluminous, but difficult for us to obtain, especially if it's out of state or whatever other processes are in place. So I don't think there's an exception or this stopgap measure as it is. I don't know that the author would have any interest in that. So that's my first comment. And secondly, is I remember the representatives of our staff, the labor representatives, being quite engaged in the conversations that we had as the internal policies were being developed. Have they weighed in on this bill yet? Because it's going to have a significant impact on our staff. I just wonder if they've gone on record or, to your knowledge, engaged in any way.
To my knowledge, I have not specifically engaged with them. It's something that we were waiting to see what would happen in the policy committees and the appropriations committees before we, I think, took a more proactive approach. But that is certainly something that we'll consider if the bill continues to move forward and goes to the second house.
Okay. I'm always mindful that once a legislator gets on record with the vote, sometimes they're very reticent to change their vote on something that's substantively the same, even if it's been very much amended, because they'll always be subject to being accused, oh, you flip-flop or something. It's an ethic in the legislature. They get really very narrow about when they change their vote on the same bill number. So I'm just mindful of, you're our legislative expert, but want to keep that in mind, that the further it gets down the road past appropriations, of course, the more people may be reticent to change their vote going forward. That's all I have to say. And I know we're in your good hands. Thank you.
Commissioner Baker raised some excellent points regarding the legislative process. But Councilor Nakano have, in terms of the fiscal impact, given that this bill's in the policy committee, and if it's passed, moves along, it'll go to appropriations. Has there been an in-depth analysis of the staff impact from a cost standpoint? In other words, if this bill theoretically were to become law, what would be the cost to add additional FPPC staff to make sure that the commission is in compliance with the act? Because if this, became a stall tactic, if this bill was implemented, the issue of staff resources would be key. So, thank you.
Yes, thank you for the question. And to clarify where this bill is in the process, it has passed out of the Assembly Elections Committee and it's headed to appropriations. So staff are in the process of that analysis. We anticipate it will be several positions, but I don't have an exact figure. We're still working on that. Thank you.
But it sounds like it would be significant. That's what I'm hearing from everybody in the room. I think that's something to certainly note here. You mentioned there was an amendment to the bill after it was introduced. What was the amendment?
The time limit would apply only to violations or alleged violations occurring on or after January 1st, 2025. So I guess it clarifies that the bill would not have a retroactive effect.
Okay. Did the author explain what the basis was for introducing that amendment?
I'm not sure.
Yeah, no worries. We can follow up with their office. Ms. West, do you have a comment on that?
Sure. I just want to talk about the fiscal a little more.
Sure.
So, for instance, this is going to make it to where we're condensing the period that we have from 5 years to 2 years, significantly tying enforcement's hands and making us go through the process more fully in the administrative realm or even the civil realm. And so with that said, I mean, you're basically at least putting 10 more positions in enforcement, because you're saying you have to do what you're doing, but you have to do it exponentially faster. And so what I take this bill as is we would like to fully fund you so that you can really regulate the whole state. So I'm looking at it as perhaps this is the time that you double the size of enforcement and you make sure that these are hitting these 2-year marks. We also have to consider the impact on the legal division, because this would create quite a bigger workload for them because they are the probable cause officers. So you're talking about doubling the amount of probable cause hearings, because then by the time you're making these things go through the process in order to meet all these deadlines, you're also burdening the legal division with that aspect. And so the amount of audits that would have to be done, because as we say, we have an independent audit division, and they get requests from the enforcement division to look at records. And so in those investigations, they would probably have to do that quicker, because it's going to be quicker for an auditor to do an evaluation of campaign records. Generally, there's some investigators that are very good with spreadsheets and numbers, but generally an auditor would be able to do that workload. So we're talking about a full agency of fiscal effect. And so that's what's taking staff a minute to make sure that we're taking all of that in consideration, because as Commissioner Baker said, we've already been addressing this and we have been very successful. The last update you got from Chief Lindsay shows that the Enforcement Division has taken great strides and reorganized and added staff and has been meeting the goals the commission has set. So to me, this is unnecessary legislation that is interfering with what we are already doing in our efficient way that takes in the staff's considerations and concerns. But from a fiscal point of view, which is where I'm coming from, we're going to make sure that if this goes into effect, we have every resource to meet it. No case left behind.
That's an excellent breakdown. I appreciate you running through that. I think it's also important to commend my fellow commissioners and staff for the excellent work they've done eliminating, or I should say reducing, the enforcement backlog and adopting enforcement regulations that have really made it clear that timely resolution of cases is a priority for the commission. I think it's clear to the public that that's a priority for us. With that, any other comment from commissioners? Great. Public comment on this item? Seeing and hearing none, why don't you go ahead and move on with the update, Ms. Nakano.
Thank you for those comments and questions. Next bill is AB 3239 by Assemblymember Carrillo, relating to emotional support animals and airline travel. The bill is new since last month's commission meeting. It was introduced by Assemblymember Carrillo and would allow campaign funds to be used to pay or reimburse airline travel expenses related to an emotional support animal belonging to and traveling with an individual whose airline travel may be paid for or reimbursed by campaign funds. The bill cross-references a definition of emotional support animal from the Health and Safety Code, which defines the term to mean an animal that provides emotional, cognitive, or other similar support to an individual with a disability and that does not need to be trained or certified. These costs will be reported on campaign statements, and the bill passed in the Assembly Elections Committee 7-0 with Assemblymember Bennett not voting. SB 948 by Senator Limon and Assemblymember Zuber relates to how campaign funds may be treated when a candidate does not file a declaration of candidacy to qualify for the primary. This, of course, was the subject of the regulation project by Senior Commission Counsel Zach Norton. At last month's commission meeting, and as discussed earlier today, the commission paused a regulation project that addressed two scenarios, one of which was addressed in this bill. The commission asked me to reach out to the author's office on the second scenario addressed by the regulation project, and the author has amended the bill to address that scenario as well. Under the amendments, a candidate who wins an election outright in the primary without advancing to the general election would be permitted to transfer any general election funds to a committee for a subsequent election to the same office with attribution to specific contributors. The language tracks option 2 in the regulation project, basically word for word. And this is one of the three bills that has not yet been heard in a policy committee. It's set for hearing next week. Is there any additional questions or conversation on that one? Oh, I see Commissioner Baker.
Go ahead.
Thank you, Mr. Chair. On this point, I just want to make sure it applies just to the scenario that's described, meaning you win the primary outright, as opposed to someone who wins the general and has leftover funds. Would the provision that's being contemplated by the authors be our scenario too, or would it be broader in any way? Because I'm thinking of many instances where, I mean, ultimately, it sets up a scenario where we're going to be treating some like differently. Some people can carry over to a future election with attribution, and some will not have to do attribution. So I just want to make sure I understand how what's being proposed or accepted by the authors, how closely it matches our scenario two, and how it affects the people who don't win outright in the primary. They win in the general. They have leftover general election funds and can otherwise carry over.
It does apply only to the scenario that was addressed in the regulation project. So someone who wins outright in the primary and does not advance to the general. That answers your question. Otherwise, might have our legal division assist.
That's answered my question. I appreciate it. And great.
Any public comment on that, Bill? Seeing none, let's go ahead and move on.
All right. Next bill is SB 1111 by Senator Min. This is in the area of Section 1090 relating to conflicts of interest in government contracts. The bill would create a new remote interest for certain family members' financial interests. That bill passed in the Senate Elections Committee 6-0. Senator Hurtado has 3 bills in our jurisdiction this year. All 3 of those bills passed out of the Senate Elections Committee. Those are SB 1151, requiring registration and reporting for foreign agents that engage or that attempt to influence legislative or administrative action. SB 1155, creating a 1-year ban on lobbying for former heads of state administrative agencies. And SB 1156, requiring the financial disclosures of board members and certain employees of groundwater sustainability agencies to be filed with the FPPC. For SB 1155 on the 1-year ban for former heads of agencies, the bill was amended to provide that the 1-year ban applies only to appointed officials only if they receive a salary for their appointed position. Previously, it would have applied to all appointed officials of former appointed officials of state administrative agencies. SB 1170 by Senator Menjivar would authorize the use of campaign funds for mental health expenses for candidates, certain candidates and elected officers who are candidates. This is another bill. Yes.
Commissioner Ortiz?
Oh, understood.
Thank you.
This is another bill that has yet to be heard in the Policy Committee. It will be heard next week in Senate elections. To sum up the Commission's general feedback from last month, I think there was no question that candidate mental health is important and candidates deserve to be able to pay for treatment, but there was some concern about whether expanding permitted use of campaign funds was consistent with the Act, given the existing prohibition on use of campaign funds for candidates' healthcare expenses. The Commission had asked about the origin of that provision and why healthcare expenses are explicitly prohibited from having campaign funds spent for those purposes. Our executive research assistant examines the 1989 bill file for the bill that added the personal use restrictions to the PRA. The general prohibition on personal use of campaign funds was transferred from the Elections Code to the PRA, but the specific prohibition for healthcare costs appears to have come from an attorney general opinion that was codified by the 1989 bill. The opinion took the position that campaign funds could not be used to compensate the candidate or pay for their healthcare expenses, and this appears to be based on interpretation of the existing law of that time, which prohibited the personal use of campaign funds, defined as an expenditure which creates a substantial personal benefit with no more than a negligible political, governmental, or legislative purpose. So the prohibition for healthcare costs exists in the Act today because the Attorney General at the time interpreted healthcare costs to be expenditures that create a substantial personal benefit with no more than a negligible political, governmental, or legislative purpose. So that's the origin of that provision in the PRA now. The author's office and sponsor have reached out requesting technical assistance with amendment language that they think is responsive to some of the other questions and comments that the Commission raised about the bill last month. They do understand that any assistance provided at this point would be purely technical, and the Commission has no position.
I'd raised this concern before when we dealt with this bill, and it's the tension that exists, the need to disclose information expenditure, and the impact that disclosure of mental health problems is going to have on the candidate and the candidacy. So, I mean, I'm just sharing my concern that I shared before. It's a tension that is difficult to resolve, I think, because there's a need to know how the candidate expenditure. And there have been cases where the candidate gets impacted. There's a rumor now in writing that he or she has mental issues.
Comment, Commissioner Baker?
I appreciate that. Commissioner Ortiz stated that very well and explained it well in the prior meeting and in this one as well. I add to that, I just want to raise this concern. It's very hard to see how this isn't quite closely personal, personal benefit. It might be one that we'd love to see people be able to have, but it's hard for me to see how this is consistent with our rules, the interpretation you just mentioned, and even the statute. We'll see where this bill goes, but as much as I like the hope that people have more access to mental health services, that there's more embrace of people being open and honest about it and supportive of others in engaging with the mental health care services, it's just hard for me to square that with what campaign funds are and the rules around them. I kind of feel that way about the support dog as well, but we're just going to see where these go. And it's not to tie your hands in being able to provide technical assistance to them. It's just giving both the author and the advocates who were so passionate when they spoke to us some realistic feedback, at least from this one commissioner, on the appropriateness of our engaging in the legislation.
Commissioner Baker, any other comment on this legislation? Any public comment on?
I see Commissioner Wood. I'm sorry.
Thank you for that. I think I know where this would all head if we were to really put it up for a vote. I just want to repeat, in case Ms. Nakano is around anybody who's interested in this, as we start to see more and more kind of categories of things that get offered up as potential uses of campaign funds that wouldn't violate the personal use prohibitions, the real thing they might be able to do for candidates is to allow for a salary to be taken. And then the only disclosure that happens is I need to take a salary, which is like people already know if you're poor for the most part, or if you're not able to support yourself when you're running for office. And so that I don't think that brings any additional stigma in the way that reporting, the need for mental health type support would. That said, I mean, if there were a legal way around it, I would support it. But I don't know that there is, because I haven't followed up that closely on it. So just in case you're around and you hear people say, gosh, this feels like it would be really burdensome on staff to have to make all these independent determinations around personal use, you can say there is an answer, and the FEC just did it, which is allow for a salary.
Thank you. Commissioner Wilson?
Actually comment, but I think, Commissioner Baker and Commissioner Wood raised some, key points, but as it relates to the personal use and prohibition of campaign funds, if there's a way that campaign funds can be used to provide security for elected officials, then we should be open to looking at ways that mental health issues can be covered. So I just want to be on the record saying that that's an important issue to look at if we can get to the point where it can be implemented within the, the scope of, the act and other applicable laws.
I agree with that. I think one difference between that context and this one is, and to be honest, this is a new bill to me, but would there be any subsequent reimbursement by the official of the costs related to the medical, or I should say mental health expenses, similarly to how there would be in the security context?
No, I don't believe there would be any reimbursement. They would be able to use campaign funds, and there would be no expectation of them returning those funds. For the security expenses bill, the reimbursement applies to tangible items, but not to, for example, if they hired a security guard or something non-tangible. There's
And then I recall the initial version of this bill applied solely to candidates and not to public officials, so elected officials. Has that changed, or this is going to be solely applicable to candidates for office?
Thank you for bringing that up. I think the bill has not yet. That was a misstatement on my part. It does only apply to candidates who are non-incumbent at the moment. They are considering. The commission had previously had feedback that maybe it makes sense to, or would be more consistent to allow incumbents also to use funds for mental health expenses if they meet the criteria of not having health care or their health insurance otherwise doesn't cover these expenses. So they're considering that amendment, but currently it only applies to non-incumbent candidates.
Okay, that's helpful. And I want to thank you again. I believe Commissioner Baker and I brought up at the law and policy meeting that we wanted to get that legislative history on that piece as to why this was an explicitly prohibited use of campaign funds. So it's very helpful to hear that additional background. Any other feedback from commissioners on this bill? Okay, seeing none, any public comment? Excellent. Let's move forward with the next piece of legislation.
Thank you. Thank you for that feedback. Next bill is SB 1422 by Senator Allen. This bill would expand the disclosure requirements for individuals and entities that pay for travel for elected officials. The bill passed in the Senate Elections Committee 7-0. California Clean Money Campaign is sponsoring the bill, and there was no opposition in committee. The bill expands the existing disclosure requirements to require disclosure for any individual or entity other than governmental entities and higher education institutions that make payments for travel by an elected officer if those payments meet certain spending thresholds. The bill also expands the information that would be disclosed to include the name of the donor, if that donor had reason to know that their donation would be used to pay for elected official travel, and the cumulative amount of their donations. The lack of reporting of travel payments has been an issue that the Commission has expressed interest in addressing. FPPC staff are continuing their analysis of the bill and the issue broadly and may have future suggestions for improvements.
Quick comment on this one. So it looks like this bill would result in the current threshold of 1/3 being eliminated, correct?
Yes, currently the entities have to reach 1/3 of their total spending on these kinds of travel payments for the disclosure requirement to be triggered.
Okay, thank you for clarifying that. I think it'd be helpful if any of the organizations, whether nonprofits or otherwise, that are going to be impacted by this, could consider it and let us know if they have any feedback. I don't believe we've been contacted by any of those organizations, just to hear what their thoughts practically in terms of the impact of this legislation. I also noticed that government agencies were exempt from this. Did the author explain what the basis was for that exemption?
I'm not immediately aware. I can look more into that.
Okay, yeah, that would be helpful. Excellent. Any other comment from commissioners on this item? Seeing none, any public comment? I don't think we have any, so we'll move on to the next item.
Thank you. Next bill, SB 1476 by Senator Blake Spear. This bill would clarify that the State Bar of California is required to have a conflict of interest code, and the Board of Trustees and designated employees are required to submit SEIs or Form 700s. The bill passed in the Senate Elections Committee and the Senate Judiciary Committee and was amended to add Senator Umberg as a co-author. And this bill was requested and is moving through with the work of the State Bar of California. Last, there are 3 bills amending Section 84308 relating to contributions to agency officers and when those officers are disqualified from participating in agency proceedings. The first bill is AB 2911 by Assemblymember McKinner. Previously, this bill reversed all of the changes made by the 2022 bill SB 1439 by Senator Glazer. The bill was amended to reverse all of those original changes in the bill, and instead it makes only one substantive change to existing law. It raises the contribution limit in the section from $250 to $1,500. So contributions would have to reach $1,500 before the disclosure and disqualification provisions would be triggered. The bill passed in the Assembly Elections Committee 7-0. The author committed in committee to working with opposition, including California Common Cause, on a lower dollar amount, possibly by tracking inflation. The second bill on the subject is SB 1181 by Senator Glazer. This one is new for the commission as well. The bill previously related to a different area of law and was amended this month to create a new agenda notice requirement that describes the contribution limits and the disclosure and recusal requirements. The bill passed in the Senate Elections Committee 6-0, and the bill was amended yesterday per committee suggestion to write the agenda notice language in plain language rather than as a restatement of the statute. The intention for this bill is to add additional components requested by local jurisdictions that will help with compliance. The specifics are still being worked out by the author and stakeholders, so I will keep the commission updated as that develops. The last bill on this subject is SB 1243 by Senator Dodd. It narrows the scope of Section 84308 in multiple ways. This is the third and last bill that has not yet been heard in a policy committee, and it's also set for next week. At the Law and Policy Committee, the committee expressed that if the contribution limit will be increased, it should be something that is consistent with other limits in the PRA, such as $500 or $1,000, which are other monetary thresholds that occur frequently in the Act. Commissioner Baker also asked about the provision that provides that a person is not a participant if their financial interest in the decision results solely from an increase or decrease in membership dues. I spoke with the author's staff, and they said that this could include any entity that has paying members that participates in these types of proceedings. They gave the Chamber of Commerce as an example. Last, there was a question about the exception in the bill for housing development projects that comply with a certain area of law. Based on initial analysis from the legal division, though the bill language is not entirely clear, this appears to be a broad exception for housing developers. Under the cited area of law, jurisdictions, to elaborate on that, jurisdictions must establish a housing element every 8 years that includes information that explains how the jurisdiction will address their share of housing needs if housing developments were to occur. And as I mentioned, the bill language is not entirely clear, but it appears to be saying that if a housing development project conforms with the jurisdiction's housing needs plan, then Section 84308 doesn't apply. And we're interpreting this to mean that it's more of a broad exception for housing development projects. And that concludes my update, but happy to answer any questions on those bills or others.
Thank you, Ms. Nakano. I know, I believe Commissioner Baker has some comments on the 84308 pay-to-play bills. I know all my fellow commissioners have been dealing with this for a long time, and I think this specific item is another example of why it's so important for us to get feedback from the regulated community, from stakeholders on these sorts of issues, because my understanding as this legislation went through the process, there wasn't as much feedback, and then once it went into law, then we started to get massive amounts of feedback on this issue. So the earlier we can tackle these sorts of items, I think the better. So with that, I'm going to throw it over to Commissioner Baker so that she can discuss.
I don't have a lot beyond what we mentioned in Law and Policy. Thank you, Commissioner. Thank you, Chair Silver and Ms. Nakano. You addressed the question about membership, and it sounds like they said the Chamber of Commerce, for example. I wonder how this affects labor organizations, because they're also very robustly involved in advocacy at the local level and want to make sure certainly their voice should be heard. But I think that's the only other follow-up I would have, is how that membership provision is it expanding any exception that the original bill may have already had for labor organizations, public or employee related or trades related. And otherwise, I don't have further comments beyond what we maybe shared in law and policy.
Excellent. I think it'd be helpful just to reiterate the concerns, thoughts that at least I had during that law and policy meeting in regards to the contribution amount, right? I prefer we avoid arbitrary numbers, thresholds, etc., where possible, right? And we had the 1,500 number introduced, like you mentioned, for the Assemblymember McKinner's bill, and I suggested during the law and policy meeting that perhaps if someone were to pursue raising that threshold, if they were to find it to be appropriate, that we'd look for a number like 500, which is the income threshold, which would preclude, in some cases, a public official from participating in a governmental decision, right? And then you have 1,000, which sometimes during the election cycle is going to trigger a LCR report, right? Which would have the additional benefit of providing notice to that official again that there is this contribution, and 84308 may prohibit them from participating. So I wanted to give some additional background as to where we came up with those alternative numbers. And that's all I have on those three bills. Any other comments from commissioners? Commissioner Wilson?
Yeah. Councilman O'Connell, this is a question that may have already been considered. And while I read the analysis, I didn't read the whole bill, to be quite honest. But is there any cost of living adjustment factored in? So, for example, let's say the number is increased. But 10 years from now, would the number stay the same, or is there any consideration of factoring in, well, over the next decade or 2 decades, the number should be adjusted based on, cost of living adjustments and so forth?
There's currently no cost of living adjustment in the bill. I'm not sure that has come up for discussion at this point. There are some cons that I've heard about cost of living adjustments, and that those relate to creating some uncertainty for the regulated community, since the amount changes every year or so. But generally, I think it's helpful to have that certainty of this is the amount, and then if the legislature wishes to increase it, then they may do so in legislation. But there's kind of pros and cons on both sides.
The gift limit, how it's adjusted from year to year. So okay, thank you.
Campaign contribution limits are adjusted. Is it at each election cycle based on that same formula?
Adjusted.
Okay, excellent. Thank you for clarifying. Okay, that's I think that's all we have in terms of commissioner comment. Public comment on this item? Okay, seeing none, I think we're going to move to take a quick break, and then we'll reconvene. And what's typical, Sasha? 15 minutes? 10 minutes? Okay, 10 minutes. Thank you. Well, welcome back to our meeting. We're going to move on now to the executive staff reports, item number 10. And we have Enforcement Division Chief James Lindsay. Welcome back.
Thank you again. The Enforcement Division staff report is as submitted this month, but I'm happy to answer any questions that you might have from the report.
I don't have any questions. Do any commissioners have any questions on the report? Excellent. Do we do, Sasha, public comment for all the reports at the end or public comment on each one of the reports?
Either way, usually we do it at the end.
Okay, why don't we do it at the end?
All right, thank you.
Okay, and now we have Chief Shaw for the Audits and Assistance Division. Good afternoon.
My report is submitted as well, but I'm happy to answer any questions.
Excellent. Well, I don't have any questions. Commissioners, any questions on the report? Okay,
All right, thank you.
thank you. Now we can move on to our General Counsel, Dave Bainbridge.
I'll fall in line. I don't have anything to add to what's in the report this month.
Excellent. No comments from me. Any comments from commissioners? Okay, let's move on to Acting Chief Wang, Administration and Technology Division.
Commissioner, and I will submit the admin and IT report as it is right now. But I do have some update for the March 1st group. So as of today, we only have the 3 non-filer for the March 1st group. So we are close to more than 99% for March 1st group to file the Form 700. And the SCI unit already reached out that 3 non-filer. So hopefully next report, we're going to reach 100% March 1st group filing. And for the another group, which is April 2nd, 2023 annual filing, SCI unit staff continue working on the processing of the statement. But due to the abundance of the paper filing, we are still uploading all the paper statement we receive. So if we got some Form 700 requests from the public, it's might still not available due to the processing time. So thanks for everybody's patience.
Great. Thank you for the update. One quick clarification. So in the March 1st group, and just to give some additional context to the public, we're talking about here are the annual Form 700s that Form 700 filers are required to file. And we have the March 1st for 87,200 filers and the April 2nd for code filers. For that March 1st group, it says constitutional officers is one of the categories.
Correct.
That includes more than just our typical, what we typically refer to as constitutional officers, right? Like the treasurer, controller, et cetera. Because I see total 53 here, which would be much more than I would have expected.
Yes, there's been more broad and also have the other on the top of all the elected officer, we have another agency. So yeah, so there's Coastal Commission, Energy Commission. So that's why you saw the people more than the 7 or yeah. Big
Perfect.
group.
That's helpful. Excellent. Any other questions, comments from commissioners? Okay, seeing none. Why don't we move on with, let's see if we have any additional. Yeah, we have one more. How could I forget Galena West, our executive director?
You add this month.
Excellent. Any comments, suggestions, etc.? Doesn't look like we have any. And now that we've come to the last one, why don't we do open this up for public comment to the extent that there is any? I'm not seeing any. I'm not hearing any. So let's move on to our last item here. Item 11, commissioner comments and proposed future agenda items. Are there any items that commissioners would like to add? Doesn't look like there are. Oh, it
Mr.
looks like
Chair.
there is. Commissioner Baker.
Thank you. It's I'm not sure if this is to add a agenda item, and I think I've brought this before. So we've during public comment, members of the public in the last year and the last few months have come forward and said, "Hey, I'm wondering where this case is." And today was an example of that. And I think I've asked in the past for confirmation that somebody follows up with those individuals proactively to let them know where a case is. I was just wondering if is there any further amount that we as commissioners in a public forum are allowed to know about the progress of that matter, that they would come back to us the next month and say, we got back to these folks and let them know that it's at this stage or that stage. I like to keep the firewall between us as commissioners and our enforcement, but I know that the public does expect some oversight on our part. And if they raise issues that they feel there's either delay or lack of communication, I'd just like to have closure on it. And would rather it be in a public setting so that it's not a commissioner, otherwise trying to communicate with someone on the enforcement side, which I know we don't do. I don't know if the proposal is that at the next meeting, we just hear at the last meeting, these individuals raised a question, we got back to them, and they have the information if it's included in a report. I just welcome the chair's thoughts and colleagues, or if we just keep doing what we're doing.
Galena West, Executive Director. So what the procedure is now is I keep track of everything and I check in with each person. So every time you guys ask somebody to do something or look into something, then I follow up with staff and keep it on a list to make sure that it gets done and that they report back to me and the chair to let us know that that has been completed. And that's the same thing with public comment. So when a public commenter comes in and says, hey, I haven't gotten updated, or this person blew me off or whatever, that's follow-up that I do individually with that chief. And then we make sure that that person has gotten contacted. What we could do in addition to that, because that's what our internal policy is that we could also have that person then at the next meeting say this was taken care of. But you wouldn't get too much more detail than that other than the person was contacted and their questions were answered to whatever extent we could.
As far as
Thank
my
you.
thoughts on that.
Actually, excuse me, Mr. Chair.
Oh, go ahead, Commissioner.
Thank you. I appreciate that. I'm actually glad I brought it up because I'm glad that the public gets to hear that. And I figured there was a follow-up. I wasn't sure if it was you or someone separately in the enforcement division. I'm not looking to create more nitpick work for you, but I think it is helpful to at least know that's happening, open to the chair and other colleagues if they want more.
I think that's a great idea, to the extent it doesn't create too much of a burden on any of the division chiefs, right? I want to make sure that if someone takes the time to write out a public comment to really consider these items, that they feel heard. And that other people who are monitoring the meetings understand that those people are being heard as well. So, I think, depending on, like I said, the burden associated with that, it could be something that would be helpful.
Thank you.
Other comment on that? Okay. Any public comment? Ironically. Okay, great. Well, then I'm going to move to adjourn today's meeting. Do I have a second?
Second.
Excellent. Ms. Linker, will you please take the roll?
Baker,
Aye.
Commissioner Ortiz,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Thank you, everyone.